Hi, my name is Mark D. Copoulos, and I'm a Philadelphia criminal defense and real estate lawyer. And today I'd like to talk a little bit about defending a slip and fall action that's been brought against a property owner. If you own property, it's important to understand that you are in a way responsible for what happens on that property. The law requires you to exercise reasonable care in the maintenance of that property. And generally speaking, if something bad happens on that property, you may get sued. And the most common situation where you see property owners getting sued in the county of Philadelphia is where somebody is on the property with their permission and perhaps they slip and fall or they sustain some sort of injury while they're on the property. And it's important to recognize that if you're an owner of property and you've been sued because somebody's been injured on your property, you may have a very strong defense to the case. Today I'd like to go through three very common defenses that property owners may have if they've been sued in a slip and fall action. The first, perhaps strongest defense that a property owner may have if they've been sued in a slip and fall is that they simply did not have notice, actual or constructive, of the dangerous condition. In order for a property owner to be liable, they need to be negligent. They need to fail to exercise reasonable care. And the only way, really, that an owner can be negligent, now there are some exceptions, for example, if there's open housing violations or something like that, but is generally if they were aware that there was a dangerous condition on their property and they didn't take any action. So, for example, if there's a nail sticking out of the floor and the tenant tells the landlord, who happens to be the owner of the property, that this nail is in the floor and they don't do anything to fix it, and there's maybe a text message or some sort of written notice given to the owner and they don't do anything, that would be a major problem. But one defense that a property owner may have in a situation like that or in another situation where an injury is sustained is that they didn't have notice of the dangerous condition. If there's no writings, if there's no text messages, if there's no communications, for example, saying, by the way, there's this nail sticking out of the floor, there's this dangerous condition, you need to come take corrective action, then the landlord can argue that he didn't have actual or constructive notice, and therefore he's not liable for the injury that was sustained because he didn't know about it. And if he didn't know about it, he can't exercise reasonable care in maintaining the premises. Now, the person who was injured may say that the owner had an obligation to inspect his property and be aware of it, but that comes down to, was there notice of the dangerous condition? And if, for example, it was something that just occurred, or it was a condition that the person in possession didn't tell the owner about, then that may be a strong defense to a slip and fall. Another defense that an owner may have of property is simply that it wasn't their responsibility to take corrective action. In some cases that we've handled, we've seen situations where the owner of the property, perhaps it's a condo, and the HOA is responsible for bringing in contractors to maintain the property. So if the tenant reports a condition that needs to be repaired, say for example a mold condition, and the owner of the property immediately contacts the HOA, and the HOA fails to take any sort of corrective action, or the HOA takes remediative action, but it doesn't correct the issue, the owner may be able to argue, I exercised reasonable care. I was not negligent. I took the action that I was supposed to take, but there was another party here that's really responsible for this injury, not me. And so the owner of the property in that situation may be able to file a cross-claim against either the HOA or the repair person and basically say, look, my actions were reasonable. I exercised reasonable care. I am not the person that was responsible for this injury. A third defense that a property owner may have to a premises liability case may be that they're simply a landlord out of possession of the property. For example, if you own a commercial property, you lease it to a tenant, and your lease says that the tenant is responsible for maintaining the property, for exercising reasonable care in keeping the property, you don't go out to the property, you simply rent it to the tenant, and a third party comes in and slips and falls, for example. The owner of the property may have an argument that it's not them who is liable. Per the commercial lease agreement that was signed by the tenant is responsible for caring and maintaining the property. You see this all the time in slip and fall cases relating to, for example, there's a puddle on the floor. There's no way that the landlord could know about a puddle that's on the floor if the tenant who's renting the property isn't washing the floor correctly or is leaving things out and it's tripped over. That's not going to be the owner's responsibility because the owner is not on notice of the dangerous condition, and the owner has basically delegated that responsibility to the tenant through the written lease. So the landlord may be able to file a cross-claim saying that if there's any sort of liability here, it rests with the commercial tenant because they assumed the same when they agreed to rent the property. So another thing to consider is a lot of times property owners will be sued in slip and falls as sort of a collateral third party to the action. So for example, if the slip and fall, say it takes place right outside the owner's property on the sidewalk, and there's a big crack in the sidewalk and the person walking by slips in the crack, they may sue the city of Philadelphia and they may also sue the owner of the property as kind of a secondary option. But in a case like that, the primary target is going to be the city of Philadelphia, or it's going to be the city that you live in, because generally it's going to be their duty to care for and maintain the actual sidewalk. Now, if it's snow or if it's another condition that an owner of the property would be responsible for taking care of, that may go back to the owner. But sometimes an owner may get sued for a dangerous or defective condition on a sidewalk or outside the property that's not really their obligation, but they get sued as kind of an afterthought. And in cases like that, if the owner is aggressive, if they raise a strong defense, if they file a cross-claim and say, look, I'm not the primary responsible party here, it's the city who had a duty to exercise reasonable care in maintaining the sidewalk, they may have a very strong defense as well. So if you're an owner of property and you've been sued, look to your insurance, see if you can file a claim. If there's no insurance, you need to make sure that you aggressively defend the action, that you file an answer to the complaint, and you understand that there's no liability unless if the plaintiff can, in most cases, unless the plaintiff can prove by a preponderance of the evidence, more likely than not, that you failed to exercise reasonable care. That often requires notice of a dangerous condition, either actual or constructive, or you may have a defense that you're not the liable party, that the liable party is somebody else, for example, a tenant who's currently in possession if you're a landlord out of possession, or maybe the city that you reside in if the accident took place on a sidewalk or outside. My name is Mark D. Copoulos. I'm a Philadelphia civil and criminal defense attorney. And if you have any questions concerning defending a slip and fall, feel free to give us a call at 267-535-9776. Thank you. Have a great day.